Thank you, Your Honor. Very quickly, in terms of my time limit, let me say that I concur with the submissions of the applicant, especially in relation to jurisdiction. Let me also say that the authority in relation to Article 177.4, that was dealt with in our courts in UC Guyana, and specifically at 135, it shows clearly that the order is read disjunctively, so that it's not only in relation to election matters, and this is what the court said. Let me now turn, for argument's sake, to assume that this court is empowered to determine the matter. By Article 177.4, this court's jurisdiction must be limited to those issues that are specified in Article 177.4. The issues that can be properly dealt with are the qualification of the President or the interpretation of the Constitution. An examination of the supporting affidavit to the motion does not disclose either of the two issues specified in Article 177.4. So the court is very clear that there are two separate issues, or the interpretation of the Constitution is not restricted to the qualification of a person for president. And if I might respectfully refer you quickly to the Interpretation and General Clauses Act, Chapter 201, or in the definition section, is defined as other and otherwise, and shall be construed disjunctively, and not as implying similarity unless the expression similar or some equivalent expression is added. So it's very clear there are two separate issues there. You all mentioned Article 133 and 90 in addition, and might I respectfully refer you to the case of Sesimoguri. And that case really is what says that where all provisions of the Constitution touching on an issue are considered together, and the Constitution must be looked at as a whole, so that we have to look at all of them together. And in Makiwan, our own Makiwan case, it went to the CCJ, it says very clearly the Constitution is to be construed as a whole, and courts are to adopt a broad, generous, and purposive approach in order to give effect to the concepts on which the Constitution was founded. So, Your Honors, it further states in the same Sesimoguri case versus the Attorney General 2005 law report of Parliament that it is a cardinal rule in constitutional interpretation that provisions of a constitution concerned with the same subject should as much as possible be construed as complementing and not contradicting one another. The Constitution must be read as an integrated and cohesive whole. So, Your Honor, the Constitution of this court is well founded, but even more so with the contention that there's an absence of rules. And Basil, the former Chief Justice of the CCJ, Michael Basil himself, and Vincent Peters, an Attorney General, and the same Chaitan, an Attorney General, that is referred to, Nelson J.A. concurring. They say that in the absence of rules made under the Representation of the People's Act, such applications should be made in accordance with the rules of the Supreme Court, and in this particular case, the Court of Appeal. So, Your Honor, I would like to leave those. And of course, remember our John Doe's case. If there's no procedure fix, we can't hold our hands. Your Honor, if I can move on quickly, and I would like to address. First of all, could I ask that at page 5, issue 3, that any reference to Article 161 be expunged? Also, wherever it occurs, it's also on page 7, dealing with issue 3. Your Honor, the question is, whether upon the true interpretation of Article 162 of the Constitution and the Recount Order, or the 6th of 2020, the Guyana Elections Commission has a duty and responsibility to determine whether the 2020 general and regional elections were fair and credible. Your Honor, we are contending that notwithstanding GCOM in its release at paragraph 5 said that it could not have clothed itself with the jurisdiction to establish itself as a court of law to determine credibility of an election, etc. We say, Your Honor, that's exactly what GCOM did. GCOM, in its order 60 of 2020, made under Article 162(1)(b) to resolve difficulties and to get to a free, fair, and impartial election, made provisions in this order number 60 of 2020 that was gazetted that gives it the jurisdiction to deal with credibility. And Your Honors will recognize that this is not a situation where elections the results have been declared and we are in a post-election stage. We haven't reached there yet. In fact, under the order that was made, we are at stage 3. So, the relevant powers that GCOM gave itself in here, in these provisions in Order 60 of 2020. 1. The third recital. Whereas the President and the Leader of the Opposition and all contesting parties agree to a CARICOM proposal for a total recount of all electoral districts as a means of assuaging the contesting parties and determining the final recount. So that tells you clearly GCOM is empowered under the order to determine the question of credibility. And the last recital is even more empowering, where it says that they are to remove difficulties and they must do a reconciliation of all ballots issued with the ballots cast, destroyed, spoiled, stamped, and as deemed necessary, they counterfoil stops authenticity of the ballots and the number of votes listed and crossed out as having voted, the number of votes cast without ID cards, the number of proxies issued, and the number utilized statistical anomalies, occurrences recorded in the poll book. It tires me. These are the powers that GCOM gave itself. These are the powers that GCOM gave itself to do, test for credibility of the elections of March the 2nd. Let's go on. Paragraph 6. Paragraph 6 is a paragraph that created the observation report form. And in this observation report form, in the workstations, they were to record all of those occurrences that occurred outside of the ballot count. And that's where all the irregularities, anomalies, and discrepancies were recorded. And going further, at paragraph 12, the order says what you would do with the observation report forms. The matrices for the recount of 10 electoral districts shall then be tabulated by the Chief Election Officer and shall be submitted in a report together with a summary of the observation reports for each district to the Commission. So again, paragraph 12 brings in the observation report. So essentially, Your Honors, the process was that whatever the count is, the ballot count, it has to be subjected to the credibility test. And that credibility test will be taken in relation to the contents of the observation forms. So if you have 49 ballot boxes without statutory documents, that is not a matter for the court to call a witness for. Because at every stage, a presiding officer, he has the power to determine the validity of a vote. He has the power to determine any irregularity and resolve any irregularity occurring in the polling station, even at that lower level. The returning officer even more so. So this is not a question for court. There are electoral rules, and the rules, the persons who act within the conduct of the elections in Guyana are trained to apply these rules. And it doesn't need a court to determine whether you need a poll book. That poll book tells you how the process of voting went, for example, and all those other requirements. So, Your Honor, it's not a question for court. It's a question for the officials of GCOM to resolve. And of course, paragraph 14 tells you what the Commission must do in the addendum. It tells you quite quickly that the Commission shall, after deliberating on the report in paragraph 12 that was sent to it by the CEO, must determine whether, so it has a discretion, determine whether it should request the Chief Election Officer to use the data compiled in accordance with paragraph 12 as the basis for the submission of a report under section 96 of the ROPA. That is very clear. They had a discretion, and the report they received from the CEO at the third stage, in every district that he summarized, he said he couldn't ascertain the results of the elections from the votes and the information supplied on the recount because they didn't lend themselves to credibility. He said that very clearly. So what was the Commission to do when they were in receipt of the CEO's report? They too had a duty to deploy the credibility test to the ballot count. But they didn't do it. They didn't do it. Because if they had done it, they would have been constrained to accept the report of the CEO that the elections were attended by a lack of credibility and called off the elections. They had a duty to do that because they are responsible for the election, the conduct of the elections until up to the moment of the declaration of the results of the elections. We haven't gone there yet. So they're well equipped. And I could move to the next issue. Whether upon a true interpretation of Article 162 or the 6th of 2020, whether the GCOM doesn't have an inherent or implied jurisdiction to cancel the 2020 elections and inform the President of such cancellation. That is the issue. GCOM cannot make an order and then resile from it. GCOM has to stay the course so that you have all these orders as to credibility in the observation reports, etc. And when it reaches the Commission, they don't apply it. They don't apply it. So let's look at the release they said at paragraph 6. It was said that the Commission cannot arrogate unto itself a jurisdiction. This is their press release. It's an exhibit in the applicant's case. The Commission cannot arrogate unto itself a jurisdiction to annul an election, since no specific power was conferred on it under Article 162(1)(b). And that is the exact case that we are dealing with it, Your Honor. The exact case. Because, first thing, it is a quasi-judicial body, GCOM. And there are cases that specifically say that if there are no rules, if there's nothing in the legislation for the Commission to invoke, what are they to do? They are a high functionary body. What are they to do, Your Honors? Well, the engine cases are very clear, and I'm surprised that at this point in time, a jurisdiction in which the engine cases predominate, where our courts have long had recourse to the decisions of those brilliant engine jurists with beautiful legal minds. I don't understand at this 11th hour why we want to debug them now. So let me illustrate what I'm saying about those beautiful minds. In the case of J. Shankar Patak versus the Election Commission, number 81, 1801 of 2012 is listed there on the list. There was the same situation. In the case, the Elections Commission, in cancelling the entire process of the election on the allegation of the use of money and horse trading and uncertain irregularities committed by 3 voters during the process of casting their votes, I wonder whether they were in the booth there with a phone, a cell phone, taking pictures to show how they voted, as recommended for cancelling of the election process itself. They contended that the Election Commission was wholly without jurisdiction and it was bad. And so they went to court. So we're making this point. That commission felt that with all the fraud and chicanery, that they couldn't allow the elections to go forward. And that's the similar situation that this election commission is in. And I would shudder to think that the Guyanese people should countenance that in the face of overwhelming fraud, generically used, irregularities, discrepancies, anomalies, that anyone would be wanted to be ushered into office on the basis of that type of flawed, illegal, certainly despicable acts of trying to distort the result of an election. Why would anyone want to enter into office under such a cloud? And how could a commission say it's powerless? Powerless. So what are we going to do? We accept that you have these things and then you say you're powerless to cure it? And these cases say you have an inherent jurisdiction to do what is right. And so let me read from paragraphs 26 and 27 what that court said. In our opinion, the Election Commission did what the Honorable Supreme Court expects from high functionary authority, like Election Commission. That even if the law and the rules are absent, I repeat, the press release said that the Commission said they didn't have any rule or any law. But even if the law and the rules are absent, even then, if the Election Commission comes across such a situation, then they have to tackle that situation. So you should not remain with folded hands. Listen carefully, Your Honors. The Election Commissioner should not remain with folded hands and pray to God for divine inspiration to enable him to exercise his functions and to perform his duties, or to look at any external authority for the grant of powers to deal with the situations. In these cases, we are of the considered opinion that the Election Commission has acted befitting its office by taking extraordinary steps of stopping the counting promptly and stopping the result of the poll, and forthwith recommended for rescinding the election notification to Her Excellency the President of India. That country was not prepared to countenance any unlawful activity. Must have seen a situation of such an election. And the contention is made by my learned friend that this system different, that was just a constituency, etc. But the rules are applicable. Guyana, under the PR system, is one constituency. So there's no different. It's one constituency. So the rule applies whether it's a single constituency or not. Because what they went on to say is that free and fair elections are the very foundation of democratic institutions. And they referred to the case of Kokavi, Belagali, and Jati, where they said, and I quote, free and fair elections are the very foundation of democratic institutions. And just as it is said that justice must not only be done, but must also seem to be done, similarly, elections should not only be fairly and properly held, but also seem to be so conducted as to inspire confidence in the mind of the electors that everything has been done above board and has been done to ensure free elections. So, Your Honor, this case shows you that when you're functioning with such high authority, like the Elections Commission, you can't say, alas, I see nothing in the law. And that's the end of the matter. So, the drug train would pass and all other unlawful conduct and activities. And Your Honor, if I refer to the Mohinder Singh case, that also says the same thing. And I'm saying also that Article 324.1 is also in pari materia with Article 162.1.4, 1B. It says this: but after the President's notification has been issued, the entire electoral process is in the charge of the Election Commission, as here. And the Commission is exclusively responsible for the conduct of the election without reference to any outside agency. We do not find any limitation in Article 324 from which it can be held that where law made under Article 32 or the relevant rules made thereunder do not provide for the mechanism of dealing with a certain extraordinary situation, the hands of the Election Commission are tied, and it cannot independently decide for itself what to do in a matter relating to an election. We are clearly of an opinion that the Election Commission is competent in an appropriate case to order repoll of an entire constituency where necessary. It will be an exercise of power within the ambit of its functions under Article 324. The submission that there is complete lack of power to make the impugned order under Article 324 is devoid of substance. So the Guyana Elections Commission under Article 162.1b, where they are required to do whatever they could do to ensure we have free, fair, credible, and impartial elections, have that power, and they can't fold their hands. So, Your Honor, we continue relying on these cases to show that at the stage 3 exercise, the Commission failed to address the issue of credibility in the light of all the irregularities, discrepancies, and anomalies, especially highlighted in the report of the Chief Elections Officer. And let me say this about the Chief Election Officer. The Chief Elections Officer has a secretariat, he has all the staff, etc. He is the workman. His work is the basis upon which the Commission is advised. And the Commission really should be slow to not to accept the advice of its chief election officer. In fact, in relation to 177, the election of the president, 177 too, when the CEO's report advice to the commission is the only advice the commission could want, and they have to take it, act on it. And it's not put sure, there has been no declaration of results here. There's no question of Article 163 kicking in. Article 163 only kicks in when there is a declaration of the results of the election. So right now, we have a situation where we have all these discrepancies, anomalies, etc. And we have the Malarian case. The Malarian case shows clearly it imposed a duty on the commission that if contesting parties raise allegations of irregularities, discrepancies, or anomalies, before they declare the results of the election, they have a duty to resolve those complaints, even to hold an audit. That's what the Malarian Authority says. And somebody said that doesn't apply here because that was a decision given in an election petition. But I don't know. I thought that it's the principle that we have to use when a court makes a decision. We don't have to go back to the election petition to reapply that principle. And in any event, in Guyana itself, in the no confidence motion, when we were dealing with the question of dual citizenship, we were all astounded 4 years after the elections had been determined that one was required to go back to say that you ought to have brought your complaint during the period allocated after the results of the elections are declared. So that it can't be that because in the Malarian case an election petition, it was determined on the election petition that that's what should be done. It means that elections commission must take advice. Because the Indian courts have it, you come over to Africa, they have it, that you can't fold your hand in the face of serious irregularities in an election that you have control the conduct of. And allow someone to be elected on that platform. And we're saying that it ought not to happen here in Guyana also. So Your Honors, I don't know if my half an hour is up. I could be guided.
Yeah.
Yes, please, Your Honor. In light of the foregoing, it is respectfully submitted that the Guyana Elections Commission, in the execution of their duties to ensure free and fair elections that yield results that are a true reflection of the will of the people, may exercise the power to cancel the elections in the face of anomalies, irregularities, and discrepancies, to ignore evidence of corruption and proceed with a declaration would be to undermine the integrity of the commission and erode public confidence in the electoral process. When confronted with such extraordinary circumstances, the Guyana Elections Commission ought to exercise its jurisdiction and declare that the general and regional elections held on March the 2nd, 2020 are cancelled, and so inform the President. I thank you, Your Honors.